Good afternoon, everyone. Good afternoon, everyone. Thank you so much for joining us today. We appreciate it. We will be speaking about fair chance housing and conducting criminal background checks, what you need to know. My name is Elise Rosemarin. I'm a Senior Vice President here at AKAM. Joining me today is the fabulous Kara Rakowski, joining us from Belkin, Goldman LLP. We also have Logan O'Connor from the same firm, Jennifer Manghisi, who is our Vice President of Transfers and Closings here at AKAM, Daniel Ferrara, who is a transfer agent at AKAM, and then again, myself. Just so everyone knows, throughout the presentation today, we welcome any questions and we'll try to have them responded to in the box. We will be recording this, so that way we can circulate the information after. And if there's any questions that you have, please let us know, and we will get to you as soon as we can. All right, so this discussion today will be discussing what is fair chance housing, what is that act, what criminal records can owners review and consider, what is the procedure for reviewing a criminal background check, how do you define a legitimate business interest, what is the scope of owner indemnification under the law, and how can we prepare to comply with the FCHA and other human rights laws. I think this is a really great topic because I know this is a very busy buying and selling period as well as renting, so very pertinent. And thank you again to our friends. Logan, I guess whoever wants to take it away. Moving to the next slide, please. Thank you.
Okay. Good afternoon, everyone.
Fair chance acting. Sorry?
I'm sorry, can you hear me?
Yes, we hear you now. Yeah.
Good afternoon. I'm Kara Rakowski from Belkin, Goldman. With me is Logan O'Connor. We are from the administrative department. We're partners in the administrative department at Belkin. Fair chance housing. So this is an act that became effective January 1st of this year, 2025. It is a statute that codifies a practice, I should say, that has been sort of in the human rights history in New York, but it has never been codified before. Has never been part of this the human rights laws, and now it is. It prohibits owners, managing agents, leasing agents, anyone who has the ability to accept a rental application from denying an individual applicant based on their criminal background, right? So it's not a complete denial, and we're going to go through the steps and what you can accept and deny, but it is a prohibition. It's really encouraging owners not to perform these criminal background checks. And in fact, if you don't perform the check, the statute actually has a waiver of liability. It says that if you do not perform a criminal background check, then under this statute, you will not be held liable if an incident occurs and a party ends up suing you based on the fact that you allowed someone into your building without performing a criminal background check. Okay.
Can I ask a question real quick? Why?
Yes.
What would the reason be for, or do you have any idea of why this, Housing Act came into effect?
So it is, first of all, the concept first came about on the federal level. Back maybe 10 years ago, there was a HUD memo, and it was internal. It was not publicly released, whereby HUD was strongly recommending that criminal background checks do not be run because their belief was that it leads to discrimination. The problem is, in order for there to be discrimination, you have to be a member of a protected class. And people with criminal backgrounds were not considered members of a protected class. That wasn't one of the enumerated protected classes. So it was never codified in the statute, but it arose first on a federal level internally, and the recommendation was not to run these checks because they felt it resulted in discrimination, because typically there are individuals of certain race groups or religions or national origins who may, or socioeconomic, at socioeconomic levels that make up the vast majority of the people who have criminal backgrounds. So they related that, and that's how it evolved, right? So first it was on the federal level, and now here in New York, the reasoning behind it is because they want to try to prevent discrimination. And the claim is that these individuals they're usually members of other protected classes, but certainly they have a hard time finding housing, and they want to prevent that. They want to encourage owners to rent to these people. That's the bottom line. That's it.
Understood.
So getting back to what this act is, it is a prohibition against even mentioning a criminal background check. You can't run a criminal background check unless and until the financial part of the application has been approved and a conditional approval is provided to the applicant. So what is a conditional approval? In a leasing situation, you'd have to actually issue a signable lease to the applicant saying you've met all the requirements, financial requirements. This lease that we're offering you is conditioned upon you passing the criminal background check. And then, and only then, are you allowed to run that criminal background check. Okay? And it's a limited criminal background check. So one thing to note is that most often, prior to this act at least, when you would run a background check for the credit history, simultaneously the agencies would run for you a criminal background check. You can't do that anymore. Under this statute, there are significant penalties if you run a criminal background check before conditional approval is offered to the applicant. So it is now a two-tier process, right? So assuming that the individual has passed the financials, you're now required to offer a lease in a rental situation, and it has to be a signable lease. What we recommend is that you include language in the lease that specifically says this is conditioned upon you passing the criminal background check.
Can I ask, so going to the next slide, which I know is about reviewable criminal history, what are some of the things that landlords are allowed to consider or not?
Right. So what they're allowed to consider is a felony conviction within the last 5 years, or a release from incarceration based on a felony conviction within the last 5 years, or a misdemeanor conviction or release of incarceration from a misdemeanor conviction within the last 3 years. You cannot consider anything beyond that scope.
Wow. And then as far as what can owners not consider?
You can't consider anything beyond the scope of 7 years or 3 years for the felony versus misdemeanor. Can't consider anything that if it wasn't a conviction, it's just an arrest. Anything that is in a sealed record, anything that was dismissed or is in contemplation of dismissal cannot be considered. One of the things that you can consider, regardless of timing, is a conviction for a sex offense. So a registered sex offender, that's one thing that the statute permits you to consider, regardless of when it occurred. But you still have to go through the steps that Logan will mention.
Wow.
Okay.
And then from an AKAM perspective, Jennifer or Daniel, what are the ways that we help our owners, go through the process from our perspective? I think you're muted. Yep.
I can jump in. So essentially with my boards, it's just about following the procedure and making sure that we're taking all the steps that have been presented to us. Obviously, with the boards being new to this, the same as us, we're really taking the lead and guiding them to make sure that obviously they're not doing anything incorrect, and we're not. Um, and basically, we take it from there, essentially. I
And
would
then
say.
if they fall out of line with this law, is it a penalty, like a fee penalty? What is the penalty associated?
Do you want to respond
Yeah.
to the?
Yeah, so if the criminal background was to be reviewed before it can be reviewed, or reviewed improperly, and a challenge was brought either before the City Commission of Human Rights or the State Division of Human Rights, the penalty that can be assessed, it's really a wide range. It can be, 10,000 to hundreds of thousands. The penalties include not only, the agency's fines, but also punitive damages and compensatory damages.
And legal fees.
And legal fees.
As well as compliance, ongoing compliance.
Wow.
So
This
right,
is
so there are
serious.
very serious.
Yes. So let's not discuss the owner indemnification under the law as well. So yeah.
Right. So I mean, just exactly what it says in this blurb here. If an owner does not run the criminal background check, this statute says that they're immune from liability in any civil action arising as a result of an alleged act of an individual with a criminal history, or a claim that the covered entity should not have sold, rented, or leased, or otherwise granted housing accommodation to that individual. What does this mean? On its face, it's an indemnification. This is brand new. There has been no litigation. We don't know how a court is going to interpret this. We don't know if that indemnification is going to be able to carry over to third parties that may be injured. What if, you're visiting your friends in a building, and after dinner you go to leave the building and you're in an elevator and you get assaulted by an individual with a criminal history for assault. You're a third party. You have no privity with the owner. Does this give the owner immunity from liability? We don't know.
So how
I
are
think
you
there's
making the recommendation to boards, who are kind of, just trying to understand this new act?
so, I think it's different for condos versus co-ops, because co-ops have more leeway on turning down or reviewing applications to begin with, right? So I think it's sort of different, but I think there's liability is going to be the same because they're still subject to the human rights laws now. So it is going to be a business decision. One thing, when Logan goes through the process of, if you do run the check, the steps you have to take, it is a administrative process that you as a board and owner have to commit to if you are going to make the decision to run these criminal checks. If you run the check, my recommendation is it's going to be across the board. You're not going to pick and choose who you're going to run this check for, right? And you need to make sure that your clients, boards understand this. You can't pick and choose. It has to be your internal policy that you run it across the board or you don't run it across the board. And then once you make a determination, if you choose to run them, then you have to understand that you have to make the commitment to carry out the procedure correctly, because if not, there is additional liability.
Understood. And then Jennifer, from a AKAM perspective, or Daniel, again, are we trying to demonstrate one way or the other to boards? Or I think this came up yesterday, can brokers or outside companies run these checks on behalf of the seller and or broker, or is it something that has to be done via AKAM?
We would suggest for the managing agent to run these checks so that we can ensure that the proper protocol is being followed. And, we have communicated to our boards what steps we are taking. And any questions, we'll walk them through any part of the process, but really from what it is that we're managing is the credit check that you see here through the initial application process. And once we get that conditional approval and the board lets us know they want to run the background check, then we will do that portion of it. We have not encountered an instant yet where something has come back on a background check. But what we have communicated is that if that is the case and the board wants to take further review with that, then it would go to the buildings council from there.
Understood. And so I guess if an outside company, not AKAM, were to handle this on behalf of a building or a board, I guess the concern would be that they're not doing the procedure correctly.
Yes, well, from us doing it, then we know that only the credit check is being pulled initially, and only when we get that conditional approval that the background check is being done. It's difficult to control when there's other third parties that are, that are running this.
And what's an example of a third party that might run it instead of us, just in case a broker is listening?
Well, some buildings might have a private investigator or some other outside company that they have been using for years, before this came into play. So the recommendation would be to have us now do it instead of that person, because it's difficult for us to know that the proper protocols are being followed.
Got it. And then as far as preliminary rejection is concerned, is there a, procedure that has to be done for, or I guess this can go to our attorney friends. Is there a proper protocol, and then would we handle that?
Yeah, let me go through the procedure in whole now, and I'll touch on that. And also to your point, Elise and Jennifer, we strongly recommend that all owners, boards, managing agents have a written policy in place that outlines this procedure, not only for your internal protocols, but in the event of a challenge, or if a case is brought, you have this ready. You can say, look, we did this, this, and this. We followed the procedure correctly.
Right. It's very important, because if the owner gets hit, or the board, whoever it is, or a broker gets hit with a complaint from human rights, one of the first things they ask when we defend these complaints is for a copy of the written procedure and the written policy. They want to see whether this is a topic that has been thought about, has been brought to the attention of the people who are handling the leasing, and what they want to make sure that this is an issue that has been worked out before to try to prevent discrimination. So that having a written internal policy mitigates, it may not eliminate damages, but it certainly mitigates it, and a lot of times reduces the penalty, especially during settlement negotiations.
Got it. And if an applicant is rejected, then they have a time period that they are able to, I guess, pursue the same, they can have a rebuttal period, correct?
Right. Logan's going to go through the
Okay.
procedure.
Perfect.
I'll go through the steps now. So obviously, first step is still your application, right? So they can still submit an application, but there should be no questions about criminal background on the application. And we do suggest a provision be added to all applications, which authorizes a criminal background check in the event that an offer is extended. So you go through the regular application process minus any criminal background check. You do your credit check. Again, still no criminal background review at this point. So you go through your whole initial process, and I should mention also, especially with condo and co-op boards, there's often an interview too, right? So even through the interview, every step in your process needs to be completed, and you need to extend a conditional offer only once the conditional offer is extended. That means every other step is being completed. Only then can the criminal background check be run. So when the conditional offer is extended, you want to make sure that's in writing, and the word conditional is in bold and highlighted, and you need to include a notice, a Fair Chance Housing Act notice that was promulgated by the City Commission of Human Rights. That needs to be included. Once all of that's done, you can run the criminal background check. If you can, we highly recommend you ask AKAM or whatever company you're using to exclude the records that you're not allowed to review, because if those are included, there is a presumption that you've reviewed them and you have to rebut them.
And that you've used them. So you want to make sure it's very limited.
So you've run the criminal background check. If at that point you decide you want to preliminarily now reject this applicant, you have to provide the applicant written notice. You have to provide a copy of the report. Like Elise said, you have to give them 5 business days to respond to the preliminary rejection. During that time, the applicant can submit other materials to supplement their criminal record, or maybe mitigate the circumstances or explain the circumstances.
But we just actually had that situation where we did a denial letter for our client, and the individual within the 5-day period came back and supplemented, and then we had to take it to the next level, which is
so once they submit that, you have to reevaluate in full. So you have to look at everything again as one whole picture. And at this point is when you make your final decision whether to accept the applicant or deny. And in the instance that I think Kara is referring to, our clients decided to accept after receiving additional information from this specific applicant.
Very interesting. I was going to ask, in a co-op, do they run the background check before or after they interview?
Is that for us or AKAM?
For you.
You have to do the interview first. You have to do every step.
The criminal background is the very last thing before they're signing a contract.
They're really just, again, the fair chance. That's the concept, right? They want to make sure that that they're giving everyone a fair shot. And then I guess the criminal, element is the last step, because that might be the indicator of a decision. That's at least that's how I'm understanding it. So the way that it's procedurally, and then would you recommend, obviously we're speaking to attorneys about this, it's recommended that you consider an attorney's recommendation, especially since this is so new, to make sure that you're compliant.
Absolutely. Also the documents, when you're offering an application to an individual and telling, with a consent to run a background check, a credit check, for example, there's language in there that has to say we're not running a criminal background check unless and until you are provisionally approved, conditionally approved. At that time, do you think the fair chance notice should be provided at that time and not wait until conditional offer?
Yeah, there's no harm in it. Yeah.
I mean, I would give them notice as soon as possible and provide. So it should be in your application. Your application should say, you're authorizing us to run a criminal background check only if you've been conditionally approved and you've been provided with a conditional offer. So there's no misunderstanding. It should appear in numerous places. I don't mind being repetitive under these circumstances.
Got it. And if you choose to not run a background check, a criminal background check, then I guess the waiver of liability is where this takes into effect.
Correct.
So I guess, and is a co-op going to have a different procedure than a condo, or it's going to be the exact same?
It's going to be the same. It's just that co-op boards, by the nature of the organization itself, has traditionally had more of discretion as to whether to accept or deny. I mean, traditionally, co-op boards could have denied for any reason at all, right? Now, they have to be careful because human rights laws don't allow that.
Got it. So are there legitimate interests, I guess, at play here where there are elements that might make this different, a different outcome?
Right. So that's the biggest question that everyone has, right? Because what is a legitimate business interest? It's not a term that's defined by the statute. It's used in the statute, but it's not defined in the statute. So that means it's going to be left up to courts and the human rights agencies to interpret what a legitimate business interest is. Ironically, they don't give us examples of what a legitimate business interest is, but they do give us examples of what it is not. And the problem is that the examples they give as not being a legitimate business interest really are examples that any reasonable person who is on a board or who owns property and leases it would think that it's a legitimate interest, right? So you're concerned about, the safety of your tenants or your residents in the building. You're concerned that so they phrase it as the applicant seems likely to commit another crime, and I want tenant safety. You would think that tenant safety and resident safety would be number one on the list for legitimate business interest. Here they say it is not. So based on what the examples they give as not being legitimate, I believe it's going to be a very, very high bar for anyone to be able to meet a legitimate business interest. We recently had a situation where the individual was a high-profile individual who became high-profile because of her fraudulent behavior, and was incarcerated and released from incarceration within the last 5 years. And one of the reasons why she was incarcerated was because she refused to pay her landlord, which at that time was a hotel, and ended up leaving eventually, owing them hundreds of thousands of dollars. So that was one of the injured parties in a whole, laundry list of others. We believe that that was enough of a connection to deny the applicant. But, we couldn't guarantee it. A reasonable person would say, well, here's the exact same situation, right? She defrauded her prior landlord, left owing hundreds of thousands of dollars. There is no difference now in her financial circumstance. In fact, she didn't qualify for the unit without getting a guarantor. So why would we think that anything was going to be different? To me, that's a legitimate business interest. I can't guarantee it because we don't know what a court or human rights would say about it.
So you
Right.
brought up guarantor, which is interesting. Does that play, would that person then be at play and have to pay out, I guess, what if she fails to pay again?
Guarantor, yes. We'd have to go after the guarantor, though.
Right.
Right.
So then is there like a fair chance, if you're does the criminality have anything to do with guarantors at all in this case, or no? Because it's behavioral?
No.
No.
No, in fact, originally when she was denied, she didn't have a guarantor. She didn't meet the financial requirements. She then came back with the guarantor. It became an issue for us because we said, oh, great, she doesn't meet the financial requirements. We don't even have to get to the criminal stuff. Once she came back with the guarantor, it became a problem because the issue that we're concerned about is non-payment. And now there's a qualifying guarantor. So, at that point, she ended up being approved.
Wow. That's very interesting. So the financial elements remain the same. It's the criminality that is more in effect for this particular act. right?
Yes, but what criminality? If it places the burden on the board or the owners to
Mhm.
determine if
Mhm.
there's a significant safety, if there's a real safety risk.
Mhm.
That's the burden is now on you to determine if there's a real risk. But how do you prove it? Right?
Right.
You can't. I will, in the HUD memo,
Mhm.
it's interesting because the two criminal issues that HUD flagged as examples of reasons for denying, this was many years ago, at least
Mhm.
10 years ago. One was someone on a registered sex list, a sex offender, registered sex offender. The other one was an example would be if the individual was found guilty of cooking meth in their unit. And the reasoning, they went into the reasoning would be, yes, it was a criminal act, but it was a criminal act in which they carried out in the unit and endangered the entire building because the building could have blown up. So that was the example they gave. I think most situations are not going to meet that type of example.
Right. And you mentioned that this is I don't know if there's particular case law to New York because it's very new, but it's been around, you said, in other states for a while, correct?
It's new. Yes, it's new to New York, but it is New Jersey has a similar statute. Other states have similar statutes.
And so is there any, best practice or, how do we help our boards, prepare and to comply with this new act? Like, what is the maybe recommendation from a
think
legal perspective?
by explaining to them that although you may want to know who's, the background of the individuals living in your building, they have to understand that once they get that knowledge, they may not be able to do anything about it. So they have to decide, is it worth it? If you have the knowledge and you can't do anything about it, but having that knowledge, is there value to having that knowledge, right? If not, then there's not a reason to run these checks. I will tell you that I can't say most. I will say most. Most owners that I've spoken with, whether they be boards or owners of multifamily buildings, it depends on who they are. So as to whether or not they're going to run the check. We represent these institutional owners that have properties across the United States and with various different jurisdictions. They want to streamline their process so they don't run the checks because they don't want to have to deal with it. And they're institutional. They really don't care who's living in their buildings, to be honest with you. Then you have the large owners who own tons of multifamily in the New York area, and major owners and developers, and they say, we're still a family-run business, and we care about our tenants, and we don't, I don't care that there may be indemnity. We want to see who's living in our buildings. We want to know. And they're still running them. And in reality, one of those large owners, when we were having the discussion, I said, well, you have buildings all over the country, even though you're a family-owned operation. How many times do you get hits on these criminal backgrounds and checks? And they said to me, in the last 5 years, maybe we got 3, and that's nationwide. Thousands of units. So how often are you really going to get it? I don't know. I think depending upon the area that the building is located, geographic area, you're going to have different numbers. I think it depends on the geographic area where the building is located.
Understood. And someone is concerned, though, if you don't run the checks, and how will you find out if an applicant is a registered sex offender?
Well, you can run a separate check just for the sex offender list.
So how would that go?
you would have to request it from the company that you order the background checks. So, and you have to tell them you do not want a full criminal check. You only want the registered sex offender.
And if you
I would
do
recommend you
that,
always run that.
yeah, if you do that, then are you still waiving your indemnity or no?
No, yes, you are. You're waiving your indemnity. But my recommendation is you have to weigh that indemnity versus someone with a criminal background based on a sex offense. That's going to be a business decision.
Mhm. I think the two, it sounds like, at least from the questions that we're getting, that the two concerns would be being able to pay, obviously, your monthlies, and then the second would be the registered sex offender, you know, from the perspective of search. So I guess it just depends on the board in making sure that there's a written policy in place, making sure that people are aware of this, because I mean, I'm a former broker and I, you know, wouldn't have known this unless it was told to me. So hopefully agents are being trained on the policy, and then just making sure things are written and having protocols in place and consulting with attorneys like yourself to make sure, especially if this is your first time, you know, looking at a written procedure, you know, making sure that there's some trained eyes to make sure that you're in compliance.
Right. And we draft those written policies for clients all the time. As well as the, you know, providing them with the language to include in their applications, and even the letters that go with the approval letter, the conditional approval letter. We draft all that for clients. The one thing I want to also mention about the sex offender list, if you don't run the check and there is a criminal, someone with a criminal history and is on the registered sex offender list, and something happens in that building, I personally don't believe that this waiver, this indemnity, is going to protect the board from that liability. I just don't. I think it would be hard for a court to interpret it this way. Anything is possible, but I think they would have a problem.
So the indemnity, even though they're saying it's going to be waived, is not a sure thing, is your takeaway?
Yeah, it's not a sure thing. We don't know what's going to happen with it.
Because
We had a situation a few years ago where someone who a roommate, there were two people on the lease. One of them had a criminal history, that was a sex offender, and he ended up assaulting a guest of someone else in the building. So under those, I think of that all the time. Under those circumstances, do I think that would pass muster with a court, you know, as far as the liability waiver? I don't think so.
Wow. So we have two questions. It's screening based on sex offender only. What are the steps we need to take? Do we still have to offer the conditional approval before running the sex offender background only?
Yes.
Okay. And then does law prohibit rejecting a convicted murderer who was released 10 years ago?
Yes, you can't. If a convicted murderer that was released 10 years ago, you can't review that history.
Wow. Okay. So we have another question. Oh, that was an answer. They appreciated it. Is there anything else, you know, again, this is a very busy sale rental period. Is there anything that people should take away from this, you know, as just you know, just keep in mind? Because it sounds like from your perspective, you know, I don't know if it sounds like it might be erring on the side of caution to not waive the indemnity, but that's my perception. But at the same time, you know, I don't know, any last thoughts?
Logan?
My last thought would just be, you know, and I know I've said this already, but just to reiterate, there are so many little steps in this process that may not seem meaningful. But if one written communication is missed or one notice is missed, it can give rise to a claim. So I would just say make sure everyone who's involved in the application process is trained on this. I would suggest you have them, sign, acknowledge that they've read the policy. And we also, in addition to written policies, we also provide, like Kara said, template written communications for a conditional offer, for a preliminary rejection, just to make sure everyone's following those steps, because one little misstep can really blow things up.
Yep.
Yeah, that's great. And then Daniel or Jennifer, from a AKAM perspective, what are the steps that we're doing to inform people about this new act? Either or. It looks like Daniel.
So in order to inform them, we're again taking the steps that were provided to us with the Fair Chance Housing Act. So again, that's going through the normal process and the application, and if it's a co-op, then the interview, and then giving that conditional approval to the applicants before obviously getting their okay to run the criminal, and then taking it from there, running the criminal, giving the criminal to the board, and then taking it from there. If the board, I've only personally dealt with approvals because I haven't seen any criminal records come back from my checks personally, but if there were, we would obviously follow the steps that have been presented to us.
Great. Thank you, Daniel. Well, we really appreciate your time, Logan and Kara. Thank you so much for joining us, Daniel and Jennifer, and thank you all. We're happy to circulate all this information after. We'll also be able to circulate a recording of this. Should you have any further questions, please feel free to reach out, and have a wonderful day. Thank you so much. Bye,
Thank you for
everyone.
having us.
Thank you.
Have a great day.
Bye-bye.